I'm sorry, a small hiccup. The Korean cases, I understand, haven't been distributed to you. So unfortunately, we'll have to do that a little later after they've been distributed. Otherwise, it'll be hard for you to follow. As they say, you'll be like the blind man in the dark room looking for the black cat that isn't there. So anyway, you'll have to wait for that little moment a little later. So let's move on, and the one we'll start with the Nepali one. Here we go. So these are the decisions we want to go through. There's about 7 all told, and you'll excuse me, a few of them I've, instead of just calling them X versus Japan, which they all seem to have the same name, which is makes it a little difficult to remember which is which. But if I can suggest one thing, that in future, totally agree you should give the cases confidentiality. Otherwise, if you disclose who they are, you're putting their relatives and everybody else at risk. And obviously, if you decline them, you may actually create status for them by saying who they are. We've actually had decisions like that years ago in New Zealand. Once helpfully, somebody decided to check a Vietnamese guy out who was a ship jumper. So he decided he would ring the embassy in Canberra to check out who he was. And of course, by doing that and the detail he gave, he immediately made the guy into a refugee. So disclosure is not a bright idea. Anyway, a number of countries now have invented systems to make cases anonymous. And in New Zealand, we've still got the same one, have you, Martin? Where they just say, right, here's country Iran, let's say. The first case will be called AA Iran. The next one will be AB Iran. The next one will be AC, as you see. And it gives you hundreds of cases you can do, thousands, without disclosing anything to it. And you can go a step further, as the British system does with that, with a number of their guidance cases where they put a little bit about a few words about what the case is about. So they would put, for example, this one was LP Sri Lanka, and then it has risks on return. So the case goes through and identifies a lot of risks in it for that sort of thing. So that at some stage you'd be very wise to, as you have more cases, to ask the courts to come up with a better system of depersonalisation, as we call it, terrible term. But it just, because who remembers X versus the state or the state versus X? It's just got no use. Okay, so let's come to this Nepali one. This case has an important conclusions in it, and some of it actually is quite in line. So I was saying a number of the judges are starting to move down the track towards a more internationally consistent jurisprudence. When it comes to interpreting persecution, it's unfortunate they still follow the life and freedom approach that we were finding problems with, but it agrees that it's an objective test, where a number of them get very confused between whether it's a subjective or objective test or a mix of both. But when it comes to the burden of proof, they're totally in line with international norms, because it says, this is what it says, straight from the English translation: it shall not be so strictly applied that persons who should be protected will not be. So that's quite a step forward. It would be better to say it will be interpreted so that people who are eligible will be made refugees. But don't need double negatives, but anyway. The protection, and then as far as protection is concerned, they go on and say, it is not a mere favour, but an obligation incumbent on state parties, considering the Charter of the UN, the UNHCR, the UDHR, that has been confirmed that a principle that human beings shall enjoy fundamental rights and freedoms without discrimination, as in the preamble. In addition, applicants are usually in a disadvantageous position. They then follow the UNHCR handbook guidance and include in that recognition of the shared burden. So, you know, there's some glimmers of light that are coming out. That decision, I think, was when? A few years ago? 2016. So it's not that old. It's the first one on that second page. Later, the court finds the Napoli was eligible, as it is reasonable he believed he would be at risk of being persecuted on return. So they don't use the ordinary person in this case. They think they come back to the person themselves. In other words, it's more of a subjective thing than an objective thing, having said it was objective earlier. But anyway, it's getting there. They also agreed, and this is important, that non-state actors, in this case the Maoists, were and could be actors of persecution in certain situations. So that, in a number of the cases, is a complete denial. They just say, right, only the state can persecute. Whereas really the correct test is a non-state actor can, provided what? Do you know what the answer is? The two legs to the persecution test: serious harm and failure of state protection. Yep. So if the state cannot reduce the level of feared harm to below that of a real chance, then a non-state actor can become, then you can get refugee status on that basis, put as simply as I can. All right? So anyway, the appellant was found a person who was unable to avail himself of the protection of his own home country. That's what I'm saying about protection, state protection, and qualified, and as I said, shall be recognised. The only sad part was, of course, that was in 1916 on 2011 facts. So it's a 5-year-old investigation of the facts, and while it's a good result for him, under an international comparison, it should only have been done prospectively as at 2016, with the latest information looking forward, not 5-year-old information looking backwards. So in this case, it could well have been the state that would, if they redid the case, it could be the bloke isn't a refugee. And so it works both ways, but on the other hand, that's what it says. We all founded fear of being persecuted on return. It doesn't say 5 years ago, and to say shall be recognised as a refugee on 5-year-old facts doesn't work. It's the same mismatch we've had all along. Okay, so let's look just quickly at the second case, which we'll consider in more depth tomorrow. And there's a little handout, I don't know if it's been put around. There's a handout on one page, which was carefully prepared by San, which gives you an overview of the Sri Lankan, I call it BCD Sri Lanka. Do you have that? It's just one page. I may have it here myself, so I can read it to you. But basically the Sri Lankan case that we're talking about came up from a Sri Lankan claimant that had applied for refugee status in about 2006, I think it was, 2006, and been refused by the Immigration Bureau, I think as it was then. They appealed. I think firstly, yes, they would have gone to the refugee counsellors and an objection claim. That also was turned down. They then went to the court in Osaka, presumably the district court, and a judge there said, no, this person is a refugee. And so, but as Sensei was saying before, but the MOJ said, oh, no, we make those sort of decisions, not courts. And then it drifted on, obviously, till 2011, when internally, according to its own rules, the MOJ said, no, you're not a refugee any longer. I can't swear to this, you may have the answer. I don't think they even asked the appellant whether they had anything to say about the matter, but they just reversed the decision of the court unilaterally, by the look of it. I don't think they ever had a hearing or anything on it, and said, oh, things are a bit different, and therefore, completely without telling the person, they took refugee status away from them, because in 2011, I think it was, so they overturned the 2008 decision of the court of their own volition. And then, after that, the person, notably, not unusually, was aggrieved, somewhat upset. And so they then went along and said, you can't do this, and that you cannot apply some form of what's called cessation, stopping the person's recognition unilaterally at the MOJ level. Anyway, it came eventually, after going through a period of about 8 years, it got to the court, it went through first instance court, and I'm not sure, I think it was upheld at the first instance one, can't remember. Anyway, finally got to the High Court in Tokyo in 2018, and I think somebody here appeared on the case with a team of people, and then that court said, no, you cannot apply the cessation clause, which is part of Article 1, the same one that includes inclusion, has a provision on cessation. It also has a provision on exclusion under F, for certain people who have committed horrible crimes or war crimes and so forth. And it's all part of the same package. And the court said in that case that you couldn't do that using what it calls prescribed procedures, internal prescribed procedures of the MOJ to reverse their decision. And they said in their arguments quite strongly, the MOJ, oh, no, we make the rules. We make the rules because it was left to us to make the rules as to how you interpret the convention. I'm just giving you the layman's version of what I think it says. We'll make the rules, and if you take that away from us, we won't be able to make the rules. And so cessation will be done in our way when we want it to. This is just giving you a brief overview of having read it about 7 or 8 times. And the court said, no, you can't do that. You cannot use your prescribed procedures, which in fact are not procedures, they're obviously legal rules as well as procedures. You can't do that. You must comply strictly with the terms of Article 1, and in particular Article 1C5, which said there must be significant changes of quite a significant nature in the country of origin, home country, before you can apply it. And also, they didn't actually spell that out, but if you're going to do that, you should do it fairly in a recognised procedure that allows the refugee to remain a refugee until total procedure as under Article 1C is carried out. They then undertook to do their own exercise under 1C5, the court did, and went through and assessed whether there had been significant changes in the situation in Sri Lanka since between 2011 and 2018, I think, yep. And as a result of that, concluded that there had not been the significance of changes. So first of all, they upheld the decision originally given in 2008 by the court, right, that the person was a refugee, and that decision was binding on the MOJ. The MOJ just could not unilaterally, using its own rules, change that and say, no, you're not. And the court then went and did its own exercise looking at cessation and change in country conditions, COI and the rest of it, and concluded, in fact, it was as bad, if not worse, than it was for people with a profile like this guy had if they went back to Sri Lanka in 2018. So they were getting much closer to the situation at the time of the decision, and said, no, that applies. And they even went on, as I mentioned before, and said, the advice you got from your own lawyers, or the MOJ lawyers, at the time when we signed up, told you that you must apply Article 1 of the Refugee Convention as it is. You can't make up your own rules. That's the legality of it. And impliedly, and this is what I was talking about with the lawyers there, that applies to 1A as much as it applies to 1C. You can't, it's all one article and it's all part of the same black letter law of the convention. So if that's the case, this case is a brilliant precedent because it says, one, the MOJ cannot make its own rules, legal rules. You can make procedural rules, but you can't make legal rules that change the terms of the actual convention, which they must have done. You cannot, therefore, dream up your own way of doing cessation. You must comply with the actual terms of it. And if you're doing that for cessation, you must do it for inclusion as well. So this is a major breakthrough. And the advice they got, by the look of it, from their own people back in the 1980s was, yes, that's the right way to do it. So the court somehow got hold of that decision, presumably the lawyers found it or something, that opinion by the prosecutor general or whatever it is, or that their own legal advisors, that said completely the opposite to what the MOJ was saying. And so it's a very strong decision. And that's why it needs to look at, we need to look at it further. But what we're doing with that decision tomorrow when we come to discuss it, and what I've been doing now is really, rather than going through it item by item or quote by quote, because it is hard to understand the English of it, I have to say, from the literal, and this is not a criticism of the interpreter, which what they have done is really just taken the Japanese and converted it into English. But the Japanese must be complex, and the lawyers will know this. I have huge admiration for you in your ability to understand Japanese legalese, as you might call it. So what we've done is, like I've just been doing, is given my understanding as best as possible to what the High Court approaches may be. And that's what we want to debate tomorrow night, particularly, on whether I'm right in that, by re-looking at particularly those of you involved and everybody else, and particularly if you look at the Japanese version and tell me, no, you're wrong for whatever reason, or you're half right, or whatever the answer is. So that's why I'm raising it now with you to look at it. And son brought it to my attention. You gave me this little one-page summary. Yep. In other words, the government notice that went out in January this year to the other government officers about that case, I don't know if it uses the actual name, but it's clearly that's what it is, went out and said to them, if you have these cases, sorry, they've told us we were wrong, we can't use our internal procedures. Well, they're not procedures, it's obviously law, not procedures, but anyway, leave it, that prescribed procedures are what the translation says. You can't use those in relation to cessation, so if you've overturned a grant decision before, and saying now, of your own volition, the MOJ is cessation, you've now got to go back and change those, and actually it's wrong, it says then, and grant them refugee status. Well, even that's wrong. What you should have done, got to have a hearing, bring them in and go through it. Cessation may validly apply. if you look at the case in reality. But they've gone further than that and said, make them refugees. In other words, make the case go away so we don't have to bother with it anymore. But that's really what they've done, and even that's wrong in some ways. But what I'm saying is, if you're going to do it for cessation, you must do it for inclusion as well. You can't just pick out one piece and say that black letter applies from the one same section of the convention and use it here. It must have the same, the declaratory effects provision must apply for inclusion under 1A2 as much as it applies under 1C5, Article 1AC5. So that's really what this important decision talks about. The only other thing I'll add at that point, which is me trying to introduce a little frivolity, if you know what that means, fun into the evening. And please encourage your judges, if you can, in the future to take what we call a KISS approach. Keep it simple, stupid. Or just with one S will be fine, just keep it simple, and not what we call a KICK approach. Keep it complex, kid. Approach. You can knock the K off as you like as well, but just keeping it complex is what lawyers have done for hundreds of years. That's why they're wealthy. Because if you keep it complex, as they used to do when I was training, when you're writing wills or probates, notwithstanding anything hereunto before implied or expressed, to mean if or but. If it means but, say but, not notwithstanding anything herein before provided, and which is what really is happening with Japanese decisions. These statements that a disposition of a positive referral of denial, lovely American words, go on and on and on, and in the end you're going, well, is this a grant or a refusal? Is it a yes or a no? You can make the language, well, particularly in English, I'm sure you can do the same in Japanese, but just please encourage them, or please encourage yourself to keep it simple. Now, the reason for it is simple, quite simple. It means you get clear thinking. And also, hello, who's the client here? Who are you talking to? Martin's an expert on writing good decisions. It's not your decision, it's the client's decision. And the clearer you make that, the better the decision. I've said a couple of times, if you want a good example, look at Brenda Hale's decision on that Brexit case. 9 minutes, simple English, totally understandable for anybody with half a brain. And that's what good decision writing is about. All issues covered, no nonsense, no extra wordage or verbiage, very well done. So anyway, that's just a little personal note. So hopefully, as I said, using the KISS approach, it appears to us usefully and comparatively very well. The court's decisions are binding on the MOJ and cannot merely use their own prescribed procedures to make their own legal assessments, i.e., as all the other member countries do, procedures only. In other words, you can make up your own procedures to do it. That's what it tells you to do. It says how you will implement it. Well, that doesn't mean the legalities, otherwise why have the convention? That's where the black letter law is, as we were talking about earlier on, and not the core legalities. Correct legal cessation decisions can only be made by following the applicable international law as set out in Article 1, and thus 1C5 of the Convention, and not internal MOJ rules. And that's really what their notice, doesn't it? That's really what it says. And from that, logically, 1A2 is declaratory, and the only applicable refugee decision in RSD, not domestic rules. So that's why it's a very important case. The court, in rejecting the MOJ submissions on this, is quite clear. It says, this is just my best understanding of the English. However, even if it's left to the legislative discretion of each country on how, and not why or the law, how the parties establish it, in other words, the procedures, not legal definitions, if the CSR had intended to limit its application to those who were receiving recognition in the parties, in other words, each country making up its own rules, it would have said so. Otherwise, I mean, it's meaningless that a convention would write something in it to saying, here's this convention, it says we want to protect, but you make up your own rules. Well, think about it for a minute. Why would you have a convention? It just defies logic to do it that way. So you can't make up another set of rules because somebody said we're having a refugee convention, which is effectively what's been happening. So they say there's no limit to limit it in any way, and that's they're really talking about the cessation clause, does not require each country to recognise them as refugees. It's because they already are refugees and all you're doing is confirming it. So the italics are mine, but that's pretty much from the word for word, as I understand the English translation. So then finally, of three cases to look at tonight, I think. And this is a very recent case, which a number of you, I think, were involved in as well, were you? I think so. Oh, yes. An Iranian case, which I think Hassan brought to my attention, and a lawyer involved in that. And thank you very much. And in this case, the court doesn't see itself strictly bound by the usual retrospective assessment approach, but takes into account very sound COI from Human Rights Watch, I think, and some other pretty good publications from 2013 and 2015, and uses that as a basis for finding the person as a refugee. And also their growing Christian involvement within Japan, and pretty heavy involvement of this person in Christian activities here. And that all post-dated the MOJ decision of 2012. The court thus finds, and again another standard here, he will have a well-founded fear, and it calls it a high probability. This is another version of another standard I hadn't heard of persecution, not a real chance of being persecuted. However, as I said, while far more forward-looking towards the current situation, and thus not purely retrospective, it is unfortunate that under the shared burden provisions we were talking about, the court didn't simply call up 2019 COI to check whether that their findings were consistent and forward-looking as of today. So that's where it took us to. So again, it's a good decision. There are several, as I say in that case, confusingly different risk levels. I said before, highly probable. At one stage they talk about real risk. They're talking about a British, and that's the same test. That's in a UK one. Highly likely, from the MOJ denial. High probability. And then another one, an objective circumstance that a reasonable person will have fear of being persecuted if the person was in that position. As I said, wow. So about 5 different tests within the same case. This is what happens when judges don't decide up front what the issues are and that they should answer. So,
the more you mention, the more likely it is that one of them might be right.
Yeah, that is a good way of putting it. Yeah, sure. Yeah, but the judge accepts them. That's the thing. Like, if he didn't like those tests, sure, why adopt them?
But the point being made is this just a translator using varying language for the same term?
It's
not. And I understand To say no.
No.
There are actually different words used.
Because they're taken from the actual cases or the COI, particularly in relation to the UK, because that's the test you use in the UK is real risk. And he's accepted all these and put them all together and said you're a refugee. So he's effectively taking all those risks as being viable risks that he should use. He does say at the end high probability as well, and that other one about the ordinary person or something or other, but the problem really is look at it in the round, come to the risk decision and make one decision on the totality of the evidence, taking into account all your information. That's what a clear decision, as Martin will tell you, why in New Zealand since 1996, every decision comes before it, objectively on the facts as found. Does this appellant have a well-founded fear, i.e. real chance of being persecuted on return to their home country? If so, is it for a refugee convention reason? Not too complicated. I have to say it did take us about 3 years to to get to the level of that, to work that out, but that's how simple it can be. And then you don't have any mess-ups after that.
There is an odd thing in human nature when you're writing decisions to try to use different language to the last decision you wrote, just for a bit of variation. Judges need to be taught the discipline of using the same language. And terms like this are critical. If you start saying real chance in one test and reasonable likelihood in the next decision, you're going to be overturned very quickly. These are the absolute key points on which the Refugee Convention turns. You can't use different language. It has to be the same language.
It started from us being turned over by the Court of Appeal in New Zealand. So we got it wrong for several years as well. And a famous New Zealand judge who actually went on to sit on the World Court in The Hague, Ken Keith, he pointed it out to us and said, you got something wrong here, and sent it back to us to tidy up. It was actually an Irishman of all cases that who was at that stage petrified of going back to Northern Ireland. We refused him, quite rightly. But anyway, that's how, and so we were turned over. The Court of Appeal said, go back and have another look. This doesn't seem to fit with the convention, and we spent a considerable amount of time trying to find this simple, and that's often the way. Issues take a long while, but when you get them right, suddenly the thing comes right. It's much, much easier to do in the future. And as Martin said, if you keep it consistent, then you've got reliable law that can be relied on and can be used for the future. And everybody who's bringing a case will have much more certainty in where they're going, and also comparatively with other countries, you get more into similar facts, similar results, so which is what you want really in this situation. So that's why I said, again, as I say, this is a case of using the KISS principle, not the other one. And as I say, I can commend that to you. I think that was all. Yep. Tomorrow, let's come on, rather than going in the last quarter of an hour, starting on a number set. This is what we'll do tomorrow. We'll do these other cases, Ethiopia 1 and 2, and the other, and the Korean cases, starting first up tomorrow. So having gone through all that, I hope reasonably clearly, let's have some questions and discussions to finish off our evening. Comments? Let's go round the table.
I wanted to ask you lawyers about this. The instruction to immigration officers says we have to accept that the High Court has recognised this person as a refugee. And so if we're going to do anything further, we have to do it by way of cessation. Has that happened? Have they gone down the path of trying to cease to recognise the man as a refugee? Yep. Well, you're acting for the man. Has he been called back to be interviewed again about cessation?
No.
No.
So they're just going to they accept that they're just going to recognise him as a refugee and not worry about cessation. No, it doesn't.
Yes, it does at the end.
Nope.
It says if you have got cases like this, you must grant them. Right at the end.
Yeah, but
not there, right at the end.
The directive to the MOJ says, therefore, if the Ministry of Justice tries to make another administrative decision not to determine his or her refugee status due to a change in circumstances after the administrative decision, it is necessary to judge whether the application of the 51 Convention will end in accordance with cessation. The court has not closed the door on the ministry ceasing to recognise the man as a refugee. The court has simply said he is a refugee. You should have determined him to be one. And the ministry, the directive that they've sent out, that says we're bound by the court's decision. We have to recognise him as a refugee. We don't get to make any further decision recognising him or not. He is a refugee. So if today we consider he's not, we would have to go down the path of cessation. That's what they say. So I'm wondering, have they tried this course? Have they tried to cease to recognise him as a refugee? You would know if they had. Yeah.
I don't think so.
Yeah.
As I understand it, when you read the last paragraph, that's just the summary.
Yeah.
In the last paragraph, as I understand it, they're telling everybody, if you've got other cases like that, if you turn to the last page of that notice.
Have you ever anyone who applies cessation after the determined refugee status? For instance, the Vietnamese, the Cambodians, those.
Yeah. Maybe that's a good question.
I think no one actually apply for cessation. So they are still the refugees.
For example, there are many, not so many, but there are some Burmese and Myanmarese who have been recognized as refugees, but who have been back to Burma.
But still they keep the refugee status.
But at least I haven't
I
heard that
think the Ministry just doesn't have any procedures.
No, that's the point.
In fairness to the Ministry of Justice in Japan, it is also very, very rare in New Zealand and in most countries.
In the world.
Yeah. Cessation is a very hard thing to do.
Yeah.
And in New Zealand, if somebody went back to Myanmar like that, we would be more likely to start to wonder if the refugee claim had been false and that we'd made a mistake. And we might look at cancellation. Yeah, not cessation, but deciding that the refugee status was obtained by fraud and so it should be cancelled.
And unwind it.
And our law has got provisions for that.
This time now history changed.
Yes,
Yeah, that's right.
Yeah. And in the last, how long have I been doing this? In the last 29 years that I've been doing this, 25 years I've been doing this, I know of only one cessation case in New Zealand, one. Yeah. And that is because the man asked for it.
Yes,
he wanted New Zealand to cease to recognise him as a refugee so he could go home.
Get on with his life.
Yeah.
Yeah.
We just don't do it. It's too difficult. And by the time somebody's been in your country for, 5 years or 10 years, they've got a wife or a husband, they've got babies, they've got work here, they're embedded in your country. And to try to remove them creates just a whole new set of problems. It's not worth it. And so I'm not being at all critical of Japan if you don't bother about cessation. Hardly anyone around the world does.
I know of no cases where they've tried it once or twice in the UK, and it just ended up to be such a quagmire, a bog to get into, that they don't bother.
Years of fighting in the courts.
Yeah, years of fighting for no real gain.
Yeah.
But the thing that's a healthy system, perhaps I shouldn't say that here, has a cancellation provision, because if you're going to have a real chance and a benefit of the doubt thing in it, you're going to get duped occasionally. In other words, you'll be taken, particularly the less experienced, the more you'll get duped. But and immigration officers particularly, there's nothing wrong with that. It's better to, because of the nature of it, it's better to say, right, I can't decide, therefore I grant, than I can't decide because it's so balanced that I turn it down. That's the wrong decision. Your job, as I was saying in the break, is to find refugees, not border to turn them around. Your job is to find them. Otherwise, why did you take on the obligations? You're a public servant whose job is to find refugees. That's why you want to have them. They're not allowed to be border officers. They need to be separate. Anyway, that's your task, but occasionally you'll get, as we say in English, you'll get conned. You'll get taken down the wrong path. And there's nothing wrong with that. And so there is a provision in New Zealand and in the UK, and they never had it in the UK. In fact, it came in about 2003 or 4 when I was there. They suddenly decided, this would be a good idea. So, but if there's fraud or something, and it happens just as much, suddenly they turn up. Suddenly a magic passport arrived in Bangkok airport, and they were able to go to Bangkok and suddenly go back to Iran or wherever they might have come from. And because the departments and immigration around the world actually talk to each other, that information is fed back. Nothing wrong with that, that's what happens. And then they say, if it was the first instance decision by the government, they say, and what we have is a system where you can come to the tribunal and they make a claim for cancellation. They tell the person, they have a lawyer, they come along and they argue whether there's fraud or not fraud. And at the tribunal, what happens is we assess again whether they're still a refugee, because there could be fraud, and I had 1 or 2 cases like that. There could be fraud in it, or things being done completely wrongly, but when you reassess them, they're still refugees, or they are refugees for other reasons. But at least it's a safety valve in the system that allows that sort of thing, and then particularly with that, because usually that's, Martin's right, they go back home or something comes up or they go and look for a wife or something, then these things happen. And so if you have a cancellation provision, I don't know how many they do, 10 a year I suppose in New Zealand or something? 5 or 6 a year?
Well, they do very few in New Zealand now because it is so difficult to remove people once they've become embedded in the country that these days we get maybe 1 or 2 a year. 15 years ago, the New Zealand government was very interested in cancelling refugee status for fraud. And we would get 15, 20 a year at least. But then the government realised that actually while they were cancelling refugee status, half the time the people had gone on and become citizens. We couldn't get the Department of Internal Affairs to revoke their citizenship. So what was the point? So we just stopped wasting money on it.
Yeah, they did. And
really, it's a cost and benefit.
Yeah, exactly.
Yeah, cost-benefit analysis.
But what it did do for the groups that were affected by it, it gave them one hell of a fright.
Yeah.
And it meant people didn't make so many fraudulent claims after that. It waked them up. But I had an Afghani woman, just to give you a classic case, Hazara woman, an elderly woman, probably about my age, and she had she'd put up a story that somebody had told her that came to New Zealand before an immigration officer in about 1998, and the officer was completely taken in by the story. The Hazara part wasn't stressed, because as you know, that's the lowest of the low, so you're more likely to be persecuted than people from the higher ranks of their society. Anyway, that happened, and when we went through her case and discussed it, and took a long while, got the information from her, it turned out she was a hell of a lot more at risk when the real story came out than she was when she'd made the original claim. So we went back and said, sorry, no cancellation, this woman is a refugee for even stronger reasons than the original decision. So it's just healthy to have these things in the law. And so I think Japan should have those in the law. I think it's totally checks and balances.
Yeah.
Well, it's a very interesting discussion, but unfortunately the time is up now. Just start yesterday by this Iranian case or kind of secession if you like to ask more questions.